This attorney attempted to accuse the judge of favoritism, but the judge wasn't having any of it.
I don't know if 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. The public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. I'm adjourning this hearing for 2 reasons: to allow you to go through the discovery to give me a cogent argument, and secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not by any means punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow. Court does call the case of the People versus James Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm hearing with and on behalf of James Dennis Whitley.
This is People's emergency motion to modify violence in this case.
Your Honor.
Yes, sir.
I didn't file a response because we got this at noon yesterday, but honestly, we also yesterday afternoon received a discovery which we've gone over. There's some issues that I certainly have with the allegations contained in the People's motion. The simplest one is under paragraph 8. It lists 4 offenses: criminal history, A and B, the same offense. 22821 is a district court case that became a felony, was found over according to registered actions. It resulted in a plea to operating off the very second offense, 31621. So that is one, that's the minor issue I have. Their description of what happened on this day contains, I think, some confusing statements. Paragraph 3, they say that the children saw the witness the assault, but in paragraph 5, they correctly state the 13-year-old son heard some screaming, glass break. He went into the room and observed the defendant sitting on the victim on the floor. The daughter, who was either 10 or 11, the brother thought she was 10, mom says she was 11. Said that as soon as he got his car keys, he left. What I think this comes down to, quite honestly, in my cursory review, my assistant has looked in a lot more detail at these things. The statements contained in the police report are not 100% consistent with what the allegations are here as far as the case is charged or not. When first asked whether or not he strangled her, she said, I will tell you that I will say that if you tell me I have to. This is not the case that they purported to be. This case is more consistent with what I explained to Judge Fink on Monday.
Magistrate Fink, but go ahead.
What's that?
Go ahead.
Miss Fink, did I say Mr.?
Sit.
Oh, Judge, Magistrate Fink, I'm sorry. You're all your honors to me. So. I don't want to get too much into the case, but what I will say is there are a huge numbers of inconsistencies between what the alleged victim said throughout her interview. This is, again, as I represented on Monday, I don't think there's much of a chance of conviction here. I will tell you that she is here. She wrote a letter to you. I've given a copy to the prosecutor's office. I will indicate, just for the record, I explained to her that I wasn't comfortable talking to her about what happened Because my belief is she may need to talk to an attorney. I believe she is supposed to talk to one on Monday. But she wrote a letter that explains how little afraid of Mr. Whitley she is. What's also not contained in the report is the report says that she called, the alleged victim called the police, and actually her friend Michelle called the police. Michelle's known Mr. Whitley for 20 years, and her statement to the police was, Mr. Whitley is not like this. I've never seen him mad. He's always has a smile on his face. Stunned that it happened. The children said, don't hear him argue, never seen her do anything before. Never seen him do anything before. Mr. Whitley is not a threat to the community. We look at the factor of the likely sentence. This, I initially had scored it as 0-17, but then when I looked at this record more accurately, because of the 10-year gap rule, he's going to be in grid B12, which is a 0 to 11 months intermediate sanction cell. It's a Class D felony. I scored for the injury to her, and I scored, which I don't agree with, but it'll likely get scored, that he exploited a domestic relation. B2, 0 to 11 months probation. And the people are asking not for a bond to secure his presence or to protect the community. They're seeking a bond that's punitive. They want to punish Mr. Whitley for what they think he did, which is not what happened, which I'm greatly looking forward to at trial to demonstrate, if they can even get her to testify to proceed. This bond was appropriately set. I guess I'll just go over what I went over with Magistrate Fink. Criminal record, 3 prior misdemeanor convictions, 2 of which exceed the 10-year gap rule that we're using a felony, guideline scoring, offer operating while intoxicated. It's always showed up. The only history of substance use or addiction is what is related to alcohol use. Certainly he has had issues with alcohol in the past. He has no mental condition. It's not diagnosed. It's not dangerous. Also, what I just said relates to the seriousness of the offense, presence, or absence of threats. And Wilson's found on that. He has had no contact with her since this incident happened. He has been exceedingly proactive. My legal assistant has been in contact with the officer in charge since this happened. The day that it was indicated that the complaint was authorized, she tried to turn him in. Last Thursday, warrant not entered. Last Friday, warrant not entered. Monday at 8:30, warrant not entered. She gets notification. She shows up just a little bit after 10 o'clock with Mr. Whitley because the warrant was finally entered. So he is looking forward to defending what happened here because these charges are not what the people allege. He is an employee. He works 50 hours a week with daily infrastructure. He just told me that company was bought out. That's the old company. Yeah, it's in transition. He does have a daughter in the area. He has 50-50 parenting time with her on paper. She's 14 years old. She doesn't always like hanging out with dad because he has rules in his house. But he does have a child here he communicates with daily. His friends are here. His job's here. He has no ties to any other community. As I said, as far as the other thing, he's been proactive in turning himself in. And he's not had contact with the alleged victim. I have a stack of emails to him. I don't know how many emails. I'm sorry, Facebook messages, probably a quarter of an inch thick. She's sending him. I love him. I love all of these things. This is my fault. You only send a text, a Facebook message to somebody else. I only got injured because you were protecting yourself from me. Again, I don't know what the true facts are. This is so new. What I do know.
Did he go to the hospital?
What's that? No, but I do have a photograph of his head split open. from something that she threw at him, most likely a phone based on her statement to the police. It happened before these other things. She denied being strangled. She said that her head hurt, not because of an injury, but because she was confused. Quite honestly, I think it was more that she was intoxicated. She did admit to drinking. She may have been less than honest about whether she drove intoxicated or not. But at the end of the day, quite honestly, Mr. Whitley's not a danger. He's an upstanding citizen of Washtenaw County. The prosecutor's office is seeking to punish him by a $150,000 bond. It has nothing to do with what her allegations were at the time, and nothing with what really happened. I don't see in here, I've only had, 27 hours to look at this stuff. The people have had longer than that. And I don't read anything in here, the people pointing out her own inconsistencies about what happened. And which affects, again, the likelihood of conviction. But what it does just come down to, Your Honor, is Mr. Whitley is not dangerous. He's going to show up. And he's been not dangerous his whole life. He's 43. This is the first time he's been alleged to have committed any act of violence against anyone. He has custody of the daughters. The mother hasn't. She's never made allegations of domestic violence in the past because it didn't happen. So if I read the motion, it seems to me that the biggest focus is about his dangerousness. Jennifer's sitting right in the hall. She'll come in and tell you she doesn't consider him a threat. Again, if the court's willing to look at it, I can show you this letter that talks about her relationship with him and the fact that she's not afraid. Didn't ask her to write it. She just wrote it. I think she would also tell you that Michelle said that Mr. Whitley, that this behavior was inconsistent with who Mr. Whitley is, based on a long-standing reputation of not being dangerous. I ask that you leave the bond as it is.
Your Honor, I think what this ultimately comes down to is the people are very concerned for the victim in this case. I'm concerned that she's writing a letter. I'm concerned that she's saying that this is her fault. I'm concerned that she's saying that she provoked this in the form of throwing something at the defendant. To me, those sound like very telltale signs of someone in a domestic relationship who has been victimized previously. I think here, what we have is a woman who ended up in the ER, receiving 3 CT scans in the head and face area, 2 X-rays, 1 for the chest and 1 for the wrist, who had 2 kids who were around when there was a domestic dispute between her and her partner. And I think it is extremely concerning to me that the fact that when the victim said she had head pain, defense counsel characterized that as a symptom of intoxication. It was explicitly stated in the police report that the defendant ripped her off the bed, slamming her to the ground, during which she landed on the right side of her face and was unsure if she even lost consciousness at that point. That seems to be the root of why she would have gotten the CT scans, being concerned for a concussion. The victim also sustained multiple visible injuries, including cuts, bruises, red marks on her upper body and her neck. I think that count one on here is charged in the alternative of assault, TBH, and or strangulation. We do not need to prove simply strangulation in order to proceed on the felony here. We can proceed on the assault TBH, which I do believe would be satisfied based off of the victim's requirement or required medical treatment as a result of this encounter with the defendant. Ultimately, I believe that the PR bond here is an abuse of discretion. And we did make an argument at arraignment for the $150,000 bond in this case, and I would be renewing that request today.
I may reply, Your Honor, briefly. I make it clear this alleged victim was previously the victim of domestic violence from her deceased husband. That can explain maybe some of her reactions and some of the issues that she had.
What does that mean?
Her children, and she said this had never happened before by Mr. Whitney. Never happened before. Okay.
But I don't understand the first part of what you just said, and how that relates to this.
She may have some PTSD related to the trauma before, but that doesn't mean that what Mr. Whitley says happened is wrong, or what how she answered the question. The first, and quite honestly,
Mr. Bennett, I'm trying to figure out what you mean by some PTSD from before. You're saying her reaction to all of this is in reference to some PTSD because of stuff that happened previously?
The prosecutor is making some comments that are speculative about her being a classic victim of domestic violence, which she was in a prior relationship. So the fact that the prosecutor sees that is unsurprising. That's what I'm saying.
Okay.
And as far as that he ripped her off the bed later at the hospital, that's not what she said. She said they fell off the bed. I don't know what she's going to say in the statement. And what's important about this, no influence whatsoever by Mr. Whitney. He has stayed away from her. He doesn't want to interfere with what she believes happened. And he's not trying to influence her to do anything. I find it surprising that they're alleging that she's in danger, the prosecutor. They don't call her to show up. She reached out to a friend of my clients.
Call her to show up to do what?
Today, to say, I'm afraid. I mean, I will say,
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
Right.
Court recalls the case of the People versus Whitman.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in this on behalf of Mr. Whitley Estate to my right. You'll make a state your name before, please. Jameson Estate.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No, my turn. The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing without notice to any side. I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow. Happy. All right.
Your Honor, for the record, my name is Jeffrey Bennett, attorney with Mr. Woodward, standing to the right. Sir, please state your name.
James Dennis Smith.
This is a continuation of the hearing. Is there anything additional from the people?
Nothing additional from the people, Your Honor.
Anything additional from the defense?
Nothing. Yes, Your Honor. One thing additional is that if the court finds that money bail is necessary, I believe that based on this case, the appropriate bail would be something like a $10,000. The current bond conditions regarding specifically a GPS tether with the exclusion zone and the drug and alcohol testing, I think, address what the primary concerns are in the report. He was intoxicated, and of course he should not be around here. But the reason I think primarily that the $150,000 insurance bond was excessive is he has no history of any violence whatsoever. In fact,
Well, can I just stop you there because I have some concerns about the representations of what happened that were made to the magistrate at the time, and some of them made to me yesterday. I went back and listened to the arraignment, and my understanding is that the alleged victim in this case contacted the defendant to pick her up from Chelsea bowling lanes or something along those lines.
he went to Chelsea Lanes to make sure she got home safe because she was intoxicated.
Right. And then after that is when this ensued. I'm having difficulty well, let's put it this way. According to what I have, he shouldn't have been driving. That's number
Well, he
one.
wasn't tested. The allegation is that he was intoxicated. I don't believe he agrees with that characterization.
Mr. Bennett, do you know what you said at that hearing regarding intoxication? Well, first of all, I don't think there are two issues there. One, he wasn't supposed. My understanding is his license is revoked with restrictions, and that his activities in going there that night would not have been within his restrictions on his license.
Okay.
Right? Secondly, with regard to the incident, the indication is he was trying to get his keys to then drive again, which would have been outside of his restrictions on his license. And there was at least the indication when there was a talk of intoxication that the defendant at that time may have been intoxicated.
I believe I said exactly that. He may have been intoxicated. Can I address that concern or not?
Go ahead.
Your Honor, if that's the concern is that he was driving when this happened, then an added condition that we can't be driving without a valid license.
No. My problem is with the whole story. Because why is he getting his keys to drive when he's not supposed to be driving? Is what I'm having difficulty even understanding the events as you're telling me they may have existed at that time.
She was intoxicated at Chelsea Lanes. He wanted to try to drive her home. She refused. She drove her cell phone. I haven't seen the alcohol test. I don't know whether or not she tested or not. He followed her home to make sure she got there okay. The parties he had generally, I believe, according to the report, it's spent most nights there. Then they got into an argument and he tried to leave, couldn't find his keys, and that's when the incident with the bed, the phone, and the glass break began. I think, in my opinion, those sort of discrepancies are only, I guess, the absolute truth, I guess, would be relevant to the bond, but they decrease the likelihood of conviction when you have the alleged victim saying that her statements weren't entirely accurate, and wishing to recant, and him saying he was looking out for her. When the argument got loud, he had asked her to keep it down so the children wouldn't hear them arguing, because he was concerned about trauma they experienced from a prior abusive relationship. And telling her to calm down actually escalated the fight, and that's when the incident happened in the bedroom, which there's a disagreement about what that was. That, at the end of the day, resulted in the injuries that were sustained by the alleged victim to her wrists, our arms, and a head. I would clear up, since you gave me a chance, there were actually, I believe the people said there were 3 CAT scans, there were 4, there were 3 x-rays. I was able to do what they provided. But I think that the key issue in this bond is somebody who is a close friend, the alleged victim, has known Mr. Whitley for 20 years and said he's not violent, that this has never happened. So regardless of whether or not there's a conviction for purposes of bond, he does not pose.
Well, if I consider him a danger, yes. I mean, what I've got here is I've got somebody that shouldn't be driving, who may have been intoxicated, who would have driven on 2 occasions when he's not supposed to be driving, in violation of his restricted license, breaking the law. Then I have this confusion about the incident. I don't even know why she would have his keys if it now is you're relating to me that he drove and then followed her, which was not the indication that I got from listening to the arraignment. And then an altercation occurs that results in what I would consider significant injuries to the alleged victim in this case, to the point of a level of medical care that was required regarding that person, which I think would have been significant. And then from that, does she have to keep moving? And then, it creates in this court's mind a level of potential danger that this individual poses, potentially to the victim as well as to the community. It certainly raises that level because he's not this law-abiding person that you say he is, because he's obviously driving. I mean, he's got those previous convictions, which led to the revocation of his license, which led to the restriction, and he's violating that twice that night, at least. So, I don't know. Sparoso, was there something else?
No, you're right.
Anything else, Mr. Bennett? Anything else, sir?
No, I just don't know. I get that he was driving when it's violating his restriction. That doesn't warrant $180,000. I do think that some cash bond is appropriate at this point. I think it should be something that policy, especially in case that the likely sentence is probation.
Understood. And what I am additionally indicating is that in listening to what was the representations at the arraignment regarding what transpired, listening to what transpired that day, hearing what is today, it's unclear to me that that's what actually happened. Because that's not what's been said on the defense side about how this whole thing comes about. I then end up with an individual that is severely injured where they're at the hospital getting the treatment that they're getting. There's some indication that that's her fault. Maybe. But then, and that the defendant is trying to get away. I just find that version of events, it may indeed be true, but I find it, at least at this point, to be sort of remarkable that that would be it. The court, go ahead. What were you going to say?
I was just going to say that sounds like testimony.
Oh, I'm sure it certainly will, but I don't have that at this. It normally would during a bond hearing. I have to assess it based upon what I see, and I would say also, with all due respect to the magistrate of this court, that making a statement of giving a PR, but then indicating that the people might file an emergency bond motion. How she'd know that, I do not know. But that, from my perspective, leads the court to believe that it was in part of the court's funding, but also as a result of what the court is looking at in this case, would find that her decision to issue a PR bond was indeed an abuse of discretion in issuing that bond. The court will leave all of the conditions that she set in place. I will set the defendant's bond in the amount of $35,000 cash surety. Defendant remanded.
When this disrespectful troublemaker angered the judge with his arrogance, the final verdict left everyone in the courtroom shocked.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue last.
I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
Do you understand what you charged with, sir?
You're compelling me to identify as Thomas Yorkstein, the legal entity on this case. The name you have on the case and who I am, it's two different people. I don't want to partake in any trust fraud or anything like that.
You will not, in any manner whatsoever,
You're trying to compel me to be somebody I'm not.
or this institution.
You have no evidence
It will not
to prove
happen.
that I'm who you say I am.
You will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
You're going to have to give me straightforward answers to my questions. You want to smile about it and laugh about it? Take him back.
Laugh.
We'll call him out later. You laugh one more time, that's 30 days. Go contempt.